Okay, we are back, and first, Commissioner Ibsen would like to put something on the record.
Thank you, Chair. Seeing as I was literally appointed yesterday, there were a lot of conversations and findings of fact pertinent to this that I just was not privy to. In order to just have the appearance of fairness, I'll be recusing myself from this vote.
Thank you. And the commissioners have decided to grant the motion to strike on behalf of Assistant Attorney General Doug Vanderbrake. So now we will go into the petition for review. So that will be first Mr. Huguenin, and you will have 10 minutes for that. So you can start now.
Thank you, Madam Commissioner. As a preliminary matter, given the extensive briefing that was submitted after the issuance of the December 23rd, 2022 initial order, and to make best use of our limited time today, I'd first like to inquire whether the commissioners have any specific initial questions about the facts, evidence, history, or law that we should address for you.
I don't believe so. No, thank you.
All right. We would respectfully request 5 additional minutes for rebuttal.
Okay.
The appellant, Ms. Touch, respectfully requests the commission exercise its considerable statutory discretion to dismiss this initial order and remand this case back to the Office of Administrative Hearings for an unprejudiced new evidentiary hearing superseding the previous defective one, including the right for Ms. Touch to propound essential discovery, call several key witnesses who have direct personal knowledge of the facts to testify, and to be able to submit to the court vital documentary evidence for determining a correct finding of fact and conclusion of law. The evidentiary hearing, 2 days of which the Office of Administrative Hearings recordings were apparently lost, suffered numerous defects on both a procedural and evidentiary basis. Some of these defects were addressed in our materials before you, and some of these have only recently been discovered by way of our ongoing due diligence efforts. These defects, when taken collectively as a whole, fully and lawfully justify the need for the dismissal of the defective December 23rd, 2022 initial order and remanding this case to the Office of Administrative Hearings for a new and proper evidentiary hearing. With respect to the technology problems, first, as outlined in Ms. Touch's petition and rebuttal, the Office of Administrative Hearings' failure to maintain a proper verbatim record of the first 2 days of the evidentiary hearings did, in fact, have a prejudicial effect on Ms. Touch's due process right to a fair trial. For example, in those lost days of the evidentiary hearing, Mr. Enriquez testified about other Riverside casino dealers making overpayments to Riverside customers in dollar amounts many times greater than Ms. Touch's alleged August 2nd, 2021 overpayments, and that Chief Operating Officer Mike McCarthy in Riverside never suspended or terminated said other dealers for their larger balance mistakes. This critical testimony was provided in the first 2 days of the evidentiary hearing, but was then subsequently objected to by Mr. Vanderbrake at the 3rd day of the evidentiary hearing, and then the administrative law judge reversed himself from the prior rulings where the administrative law judge allowed that important testimony to be admitted into evidence. Despite the fact that the 3rd day was intended to merely replicate the arguments and testimony on the first 2 days to which the recordings were lost, the administrative law judge reversed course and sustained the WSGC's new objection, in essence, giving Mr. Vanderbrake and his client another bite of the apple on this issue. As a further example of Ms. Touch not receiving a fair trial, the Washington State Gambling Commission agent Maxwell appeared unannounced at the 2nd day of the Touch evidentiary hearing. He was not on the witness list. On information and belief, this was done to intimidate Mr. Enriquez and alter his testimony. Although Agent Maxwell was ultimately instructed by the administrative law judge to leave the Zoom hearing, the fact that he appeared did negatively affect and prejudice Mr. Enriquez's testimony. In addition, Attorney General Doug Vanderbrake made what Mr. Enriquez perceived as a direct threat to him that day on the 3rd day of the evidentiary hearing when Mr. Vanderbrake asked Mr. Enriquez whether the WSGC was currently in the process of trying to revoke Mr. Enriquez's license. This action by Mr. Vanderbrake further prejudiced Ms. Touch's evidentiary hearing because then just a few days later, Mr. Enriquez was in fact served with a notice of administrative charges, thereby causing Mr. Enriquez to not be able to complete his testimony on behalf of Ms. Touch for fear of further retaliation by the WSGC staff and its agents. And on this point, it's worth bringing to this commission's attention that mere days after our last hearing before you and the submission of Ms. Touch's rebuttal materials, the WSGC staff promptly and unequivocally dismissed the administrative charges brought against Mr. Enriquez. Moreover, as referenced at page 8 of appellant's petition for review, Mr. Stroud made a mockery of the Office of Administrative Hearings court during the evidentiary hearing by laughing at the administrative law judge, alleging he came to the evidentiary hearing with a low battery cell phone, and then being allowed to run between the rooms at Riverside during the evidentiary hearing, having off-the-record coaching conversations with unknown persons, using profanity, and so forth. Aside from the above evidentiary hearing errors, it is key to understand and remedy the inherently unfair position of the application of law in the initial order. For example, RCW 9.46.153 makes it clear that it shall be the affirmative responsibility of each applicant and licensee to establish by clear and convincing evidence the necessary qualifications for licensure. However, RCW 9.46.153 provides no specific definition or guidelines as to what constitutes necessary qualifications for licensure, and it's inherently vague and ambiguous. In our assessment, this is one of the key reasons why the commission staff never brings administrative charges exclusively on RCW 9.46.153. Instead, and as logic would dictate, commission staff only brought this RCW 9.46.153 charge as a companion charge to other volitional charges. To do so adds substance because certainly a violation of any of the volitional charges levied would give the commission the authority to take action against the licensee for one of the many reasons outlined in RCW 9.46.075. However, that is not the case in the present matter. That's not the case with Ms. Touch. On each volitional charge, the commission staff failed to prove, even by a mere preponderance of the evidence, that Ms. Touch engaged in any unlawful acts. None. Zero. Nevertheless, the commission staff now asserts that the initial order to revoke Ms. Touch's license should be upheld because Ms. Touch didn't show by a clear and convincing evidence that she should not have been aware of the forehands of alleged overpayments. That is the sole basis for the assertion that Ms. Touch did not satisfy her RCW 9.46.153 duty in the initial order. That simply makes no sense. Respectfully, it is illogical and it's clearly inherently an unfair double standard against a licensee when there's already a huge disparity of power between the two parties. In essence, the commission staff would have this panel of commissioners believe that Ms. Touch has to prove by a higher standard that she didn't commit the acts that the commission staff wasn't able to even prove occurred by a mere preponderance, which is the lowest proof burden in our legal system. Such an interpretation is untenable and likely violative of public policy due to its inherent unfairness. Surely, if the commission staff was successful in proving just one volitional act, finding that Ms. Touch failed in her RCW 9.46.153 duty would make sense. But since that didn't occur here, and given the other serious defects and due process deprivations outlined to the WSGC commissioners in our previously filed pleadings and on argument here today, the only fair and equitable step to take here is to order a new evidentiary hearing. This will give the commission staff an opportunity to prove its charges, and it will give Ms. Touch an opportunity to present a full defense without the sort of inappropriate meddling that occurred in this matter by commission staff. It's not prejudicial to either party and will ensure that Ms. Touch's due process rights are honored and complied with. Therefore, we respectfully request the panel of honorable commissioners provide Ms. Touch with her due process right to a fair and just evidentiary hearing. Thank you. I reserve the remaining of my time for rebuttal.
Great, thank you. Okay, Mr. Vanderbrink?
Yes,
Yeah.
thank you, Commissioners. At the outset, we need to point out that it was unfortunate for both parties at the evidentiary hearing that 2 days had to be redone. This impacted each party. The very first day of the hearing, which consisted primarily of commission staff's case in chief and consisted of testimony from people who were not parties to this proceeding. They had to reappear, okay? So that really impacted them. It impacted commission staff because commission staff had to redo that day and redo its opening statement. Now, the subsequent day, not the second day of the hearing, but on the third or fourth, the recording, the Office of Administrative Hearings, something happened to the recording again. So Mrs. Touch needed to redo one of her days. So this impacted both sides. It had the major impact, again, on non-party witnesses who had to appear repeatedly over the course of several days to several months to testify again. But in no way did that limit Mrs. Touch's ability to put on her case. Okay. Now, before I get into the facts and the actual hearing and the important facts and the conclusions that flow from that, I need to point out, as to Special Agent Kevin Maxwell, he is not a witness in the case, was never named as a witness to testify. He was not even the investigator for the case. However, he is the assigned regulatory special agent to the Riverside Casino. And because the evidentiary hearing is a public proceeding, and because the casino's former general manager is going to be testifying, we thought it might be useful for Mr. Maxwell to hear what Mr. Enriquez was going to testify about, particularly in light of ongoing investigations involving the casino and licensees there. Nevertheless, the administrative law judge excluded Mr. Maxwell from being able to listen into the proceeding. So that's what happened there. That doesn't prevent Mr. Enriquez from subsequently deciding on over 4 other dates that were set up for him to return, to not return. Mrs. Touch's failure to secure the attendance of her own witness after repeated days and extensions by the administrative law judge for Mr. Enriquez to return is okay. That is not a reason for remanding the case. Mrs. Touch's failure to have her own witness repeatedly failure to appear. Now, we've heard a lot about everything other than the facts and what this case is about. The administrative law judge found, after hearing extensive testimony and cross-examination about the video surveillance footage of the incidents in question, the judge found that, yes, there were 14 separate incidents spread across four games over a 20-minute period in which Mrs. Touch was a player. She was also a licensed dealer employed by the Riverside Casino. Off duty, she was playing mini baccarat at the table being dealt by her friend, Mrs. Chan. And 14 separate times, she was overpaid $100 for a total of $1,400. But the judge concluded, after hearing all the testimony and considering the exhibits, that that act occurred as alleged in the notice of administrative charges. Okay. Now, from that act, the judge, however, did not sustain all of the charges alleged by commission staff. The judge found or concluded that staff did not prove that Mrs. Touch knew she was being overpaid, and therefore we did not prove that she committed theft in the second degree. And therefore, because we didn't prove that she knowingly engaged in this overpayment or cheating scheme with her friend, Mrs. Chan, that she was therefore, we didn't prove that she was cheating in the first degree or engaging in fraud or deceit. However, the judge did affirm the standalone charge, which Mr. Huguenin calls a companion charge. That is not a companion charge. Under RCW 9.46153, every licensee, an applicant for a license and an existing licensee, has an ongoing affirmative responsibility to prove through clear and convincing evidence that they remain qualified for licensure. Applied here, that meant that Mrs. Touch was going to have to explain the circumstances behind these overpayments. All right, and she had not done so. And in fact, in the record, through the investigation and the testimony and the initial order, it should be kept in mind that tied in with RCW 9.46153 and the burden to prove by clear and convincing evidence the remaining qualifications for licensure, the commission is authorized to revoke a licensee's license if a licensee poses a threat to the effective regulation of gambling or creates or increases the likelihood of unfair or illegal practices, methods, and activities in the conduct of gambling activities, as demonstrated by prior activities. That's Washington Administrative Code 230-03-085, subsections 1 and 9A. Those 14 separate overpayments for $1,400, those are the activities, the prior activity, all right? And the judge found that that activity did occur. Therefore, this is not a burden shifting scheme where if the commission proves some charges, then the licensee, now the burden shifts to them to prove they're still qualified for licensure. It's not burden shifting. This burden is present throughout, and that is a separate standalone charge. Now, to support this, what's in the record, here's the facts, okay? This is not Mrs. Touch's first problem dealing mini baccarat or with gambling rules. In 2013, she was fined for underreporting tip income. In 2018, she received a written warning for failure to follow baccarat rules. In 2020, she was fined for failure to follow baccarat rules and also received a verbal warning for loaning money to a player. After the administrative charges were issued, at some point, either after these incidents occurred or after the charges were issued, Mrs. Touch then and Mrs. Chan went to work for the Iron Horse Casino. And the information in the record shows, and at the hearing, that they were both subsequently discharged promptly from the Iron Horse Casino for alleged suspicious behavior regarding baccarat. Okay, so there we have this prior history and a post history, and in between this act, 14 overpayments, $1,400. Now, the record also shows Mrs. Touch has over 20 years of experience as a dealer, including dealing the game of baccarat. She acknowledged she knows how pay and take procedures work. She acknowledged that she gambles a lot and mainly plays mini baccarat. When interviewed and questioned about the overpayments, Mrs. Touch's answer was to deflect the responsibility for this to her employer, the casino, saying that, well, no one corrected the overpayments when they occurred. She's not accepting responsibility for this, instead deflecting the blame. And in fact, at the hearing, the testimony from Mr. Enriquez was, if the overpayments were not stopped in real time, it's as if they never occurred. Also in the record is the pattern that the investigation revealed. When Mrs. Touch was playing a single spot in the game of mini baccarat and she won, she was not overpaid and didn't quickly collect the payment. The overpayments occurred only when she was playing multiple hands or spots in the hand. The overpayments occurred when she won, but only after incurring a series of pretty substantial losses. Okay. The investigation and from the video footage revealed that others were not overpaid and proper pay and take procedures were followed for other when winnings were paid to others. Now, it stands to reason that a dealer with over 20 years of experience, also a prolific player of baccarat, who knows how the pay and take
Your
procedures
time
work.
is up. Mr. Vanderbrink.
Okay. Ultimately, we just say the administrative law judge was correct in ruling that Mrs. Touch did not establish by clear and convincing evidence that she remains qualified for licensure. If the mission of the commission is to keep gambling legal and honest, the ALJ's conclusions of law speak directly like that to that and saying that she did not demonstrate integrity, honesty, or competence in this matter. Remand is not warranted after a 9-day hearing involving multiple non-party witnesses. Mrs. Touch was fully represented by counsel. Interpreters were provided throughout. The case should not be remanded. The initial order should be affirmed. Thank you.
Thank you. Mr. Huguenon, your rebuttal, please.
Thank you, and I'll make this fairly quick. First, I want to point out the glaring fact that Mr. Vanderbrink did not bother to address the telltale signs of inappropriate pressure on a non-party witness by working with the staff to bring charges against Mr. Enriquez, questioning Mr. Enriquez about those charges on the stand, thereby having a chilling effect on Mr. Enriquez further testifying. Frankly, the administrative law judge didn't see it appropriate for Mr. Maxwell to be there, and neither do we. Mr. Vanderbrink's explanation does not make any sense whatsoever. It was clearly a pressure tactic because Mr. Hector Enriquez actually reported to Agent Maxwell, and that was the sole purpose on information and belief why Agent Maxwell was there. Mr. Vanderbrink concedes that this was a major, the re-recordings were a major impact on non-party witnesses. We agree with that. But Mr. Vanderbrink would like for you to focus specifically on the initial order, where what we're arguing here is that the process is fatally flawed. The due process to Ms. Touch is tainted, and the process needs to be revisited so that that way she can have a fair hearing. To that point, I want to address a couple of the substantive arguments made by Mr. Vanderbrink. He and staff asserted to the administrative law judge that the failure to use the index finger to size the chip stacks was a de facto evidence of overpayment. And on that, in that hearing, they rely on this video. But it should be noted that the video presented at the evidentiary hearing does not visibly demonstrate the overpayments with any sort of certainty. Rather, it appears any allegation of overpayment was exclusively corroborated by the witness testimony. And discussing this concern further with Counsel Vanderbrink at a recent CR26I conferral, my understanding is that he asserts these witnesses allegedly used panning zoom technologies to be able to count the chip stacks in the trays. However, the same technology was not used in the evidentiary hearing to reliably demonstrate that, in fact, the alleged overpayments occurred. The other thing that the Mr. Vanderbrink and the commission staff put a lot of emphasis on is the fact that Ms. Touch played at Ms. Chan's table and that they somehow conspired to quote unquote cheat. The reality is Ms. Touch was already at table 11. Then when Ms. Chan came on duty, she was randomly assigned table 11 by a drawing of the shift manager of a chip from a bag provided, and that is the standard practice to ensure randomness in assigning dealers to their starting table when they come on shift. Further, we don't know whether there were any other mini Baccarat tables active at that time, since that is a preferred game for Ms. Touch. To suggest the coordination of Ms. Chan and Ms. Touch is frankly unfounded. Finally, I would just add that at the end of the day, the sole basis for this push to revoke Ms. Touch's license stems from if the actual alleged overpayments occurred, it stems from an oversight on Ms. Touch's part. Their state's own witness, Mr. Martin, made it very clear that it's not Ms. Touch's responsibility to track that. Ms. Touch made that very clear that she was relying on the dealer to properly allocate payments. So what you're suggesting then is that a licensee on her time off, casually playing, with other things that may be going on in her life, is somehow held to the standard that she should have when she's actually dealing and responsible for the transactions that are occurring. This is the most tenuous hanging of a hat that I've ever seen in these sort of proceedings or in any sort of civil action to try and take away somebody's livelihood and to take away their complete source of income for how they support their family. And I just would again respectfully request upon this commission that it take the step here to correct these due process errors and allow for Ms. Touch to have an evidentiary hearing where she can fairly and fully present her case. And I want to thank the commission for its measured consideration on this, and I rest.
Thank you. Thank you both. Commissioners will now go back into closed session to discuss this matter. We will be back shortly.